Welcome, amigas de Centro, to this webinar marking the release of the latest issue of CENTRO Journal. Before beginning our event, I would like to just say a few words and to hold space for all that we have experienced this past week in the wake of Hurricane Fiona. I know that here at Centro, and probably among many of you, we are experiencing the full range of emotions from sadness, anger, anxiety, deja vu, and desire for community. In the past, Centro has been an important site of convening and has offered guidance to those seeking resources during these difficult times in Puerto Rico, and now is no different. We hope by the end of this afternoon to be able to release a new webpage on our site offering resources about how to address the impact of Hurricane Fiona, and also reminding us all of the lessons that we learned from Hurricane Maria. The resource page, which will be released this afternoon, will include two pre-releases of journal articles that will be coming out in the next issue of the CENTRO Journal, which is focused around corruption in Puerto Rico. It will also include a map of community organizations on the ground in Puerto Rico to help guide those of you that are seeking organizations that you want to support or learn more about. It will also include a link to the already existing web map Rebuilding Puerto Rico that has multiple layers of information about the different areas in Puerto Rico, particularly those where the hurricanes have hit. There will be also data sheets about those areas most vulnerable at this time. In addition to those resources, next Friday, we will be hosting a teach-in that will be hybrid, both in person and online, where we want to bring together scholars, activists to think about, what errors do we not want to repeat this time around? What have we learned from Maria? What do we want to do differently? What can we advocate for our communities, not just in the days and weeks ahead, but in the months and years and decades ahead of us. Our event today will be talking about legal precedents that date back over a century. How can we think about how to impact those legal ties that bound our communities and that limit the ways in which we can approach the reconstruction? So all of these issues we'll be putting together for you, and we would also love to hear from you at centro@hunter.cuny.edu about what other resources we might offer you during this time, what you want to hear from us, and what you might want to do in partnership with us as well. So thank you for joining us. We hope that those of you in Puerto Rico are comfortable and have, hopefully you must have some kind of electricity, although maybe you're on your iPhones, but we hope you're well, and please know that our thoughts are with you. With that, I'm going to turn things over to Natalie Gomez-Velez, a friend of Centro and professor of law here at CUNY. So welcome, Natalie.
Thank you so much, Yarimal, and warm greetings to everyone. And I hope again that everyone is well. Again, my name is Natalie Gomez-Velez. I am a professor of law at CUNY School of Law and currently co-chair a New York State Bar Association task force on the U.S. territories, among other roles. And today it is my great pleasure to welcome you to this tertulia, Puerto Rico and the Supreme Court of the U.S., 100 years of colonial rule. This is a pivotal moment for Puerto Rico. Our beloved Isla del Encanto encounters multiple crises. These include, as was mentioned, the catastrophic impacts of Hurricane Fiona, 5 years after the continuing devastation caused by Hurricane Maria, earthquakes, and other natural disasters. These disasters are compounded by more than 100 years of legally constructed, separate, and unequal colonial relationship with the United States, invented under what are known as the insular cases, the last of which was Balzac v. People of Puerto Rico. To discuss various dimensions and implications of the legal discrimination instantiated by the insular cases on the 100th anniversary of the Balzac case, as examined in the recent edition of the CENTRO Journal, I am honored, truly honored, to introduce our esteemed panelists. And if you can put on your cameras, First, Professor Javier Colón Morera is a professor at the Political Science Department of the University of Puerto Rico, Rio Piedras campus. He has extensively researched human rights issues regarding Puerto Rico's territorial colonial status. He holds a PhD in political science and a JD from the University of Puerto Rico. And you can read about his many publications in the written bio provided with the program today. Professor Charles Venator-Santiago is an associate professor with a joint appointment in the Department of Political Science and El Instituto at University of Connecticut. He is the founding director of the Puerto Rican Studies Initiative for Community Engagement and Public Policy in Hartford, Connecticut. His most recent projects include a series of public repositories of primary documents, again, the details of which are included in the program. And he will actually be taking an active role in the Law and Society program this coming summer. So with those introductions and a welcome to everyone, let's start the conversation. And I'd like to start, if possible, with you, Professor Colón Morera. And I have a question. It's a kind of a long question. It's a 4-part question, but I think it is one designed to capture what this volume of the CENTRO Journal is about. And so in line with this volume, can you please first give a brief background of the case, Balzac, what it stands for in terms of the separate and unequal status of Puerto Rico, where it fits among what are known as the insular cases, and why these cases that are more than 100 years old, I mean, we're talking about 120 years old even, still have implications for Puerto Rico today. If you would have that background.
Thank you very much, Natalie. It's a great pleasure to be here. This is a very happy moment for us because this has been a volume that we have been working with a lot of passion, and it's great to see how many people are interested in these topics. So, and I appreciate that you are with us today. There's a paragraph that wrote my good friend Efren Rivera Ramos that summarizes Balzac better than I would do. So I would read a short paragraph. Jesús Balzac, a Puerto Rican journalist and labor leader from Arecibo, Balzac with an S, not with a Z. In the course of the judicial proceedings, it was changed, but it was Balzac with an S. A Puerto Rican journalist and labor leader from Arecibo was convicted of 2 libel charges for publishing certain critical remarks against the American governor of Puerto Rico, Arthur Jaeger. Balzac alleged that his sentence was illegal because he had not been granted trial by jury, as required by the 6th Amendment of the U.S. Constitution. He further claimed that extended U.S. citizenship to Puerto Rico had the double effect of incorporating Puerto Rico to the United States, thus extending to its inhabitants all the rights bestowed in the federal Constitution. In 1922, Supreme Court, presided by Judge William Howard Taft, who previously had been a governor of Philippines, he had been very active in Cuba also. He had been president while the legislative strike in Puerto Rico in 1909. So he was a very, very knowledgeable character of these issues, who had been Attorney General and Governor of the Philippines, Secretary of War, and President of the United States, rejected the arguments presented by the Puerto Ricans. He determined that the concession of citizenship had not changed the condition of unincorporated territory of Puerto Rico, and that upon examination of the matter, the right to a trial by jury was not among the fundamental rights that should be granted to the residents of Puerto Rico as a matter of the federal Constitution. The idea that citizenship would result in the dissolution of the colonial relationship was thus dispelled. I love this paragraph because it's so complete that I think it presents an overall of the issues that we're going to be discussing today. We got interested in this volume because Balzac is still good law. in terms of more than anything else, the notion that the rights that Puerto Ricans have are dependent on the locality of, if they are in Puerto Rico, they have some rights of citizenship. If they live in the United States, they have another set of rights. So locality is the key consideration when trying to analyze which civil rights are available to Puerto Ricans. This is the first part. The second one is that Balzac, in a very interesting way, says that, and this is maybe where I tend to agree with Taft, that it is a political question. That the political status issue is a political question that should be solved by the political branches of government. So if you want to change the political status, you have to go back to Congress. You have to go back to the president and see if you can get that kind of change. And the third aspect is that it said that if you wanted to have all the rights of the American citizenship, that you have to leave the island and go to a state. And if you think about it, in terms of migration, in terms of the status being blocked and not advancing in any meaningful way in Congress, and the differences that still are glaring differences between rights that are available in one instance or the other, at least legally, those are issues that are very present to the understanding of the current political situation in Puerto Rico. That's why we thought that we should not we should be very conscious of the fact that 100 years have passed, and that this is still good law at the Supreme Court.
Yeah, and I think a lot of people might be surprised to hear and to understand that these cases that are more than 100 years old, right, still stand for the proposition that the Constitution doesn't apply in full to Puerto Rico based, as you said, on location. And, getting your minds around that, because people understand Puerto Rico as Puerto Ricans as having citizenship on the island. Yeah. Professor Venator-Santiago, I was wondering if you had anything to add to that just opening broad question.
So I want to add 2 points, again, to emphasize my agreement with everything that Professor Colón Morera has said. So here we have the application of the doctrine of separate and equal to a territory now inhabited by citizens. When the doctrine was adopted, it was inhabited by Puerto Rican citizens who weren't U.S. citizens, but weren't aliens. They were non-citizen nationals. And it should not be concerned with Plessy v. Ferguson's separate but equal, because that would have been a good thing for Puerto Rico. At least it would guarantee separate equality in theory, because obviously in practice is another thing. And I think that's a really important thing, because whereas Brown overturns Plessy, or at least in theory overturns Plessy, no case has overturned the insular cases. So we have a continued set of discrimination or discriminatory continuous set of jurisprudence that allows a lot of discrimination to continue to take place. One of the things that we were interested when we released the call for papers was to see how people are thinking about these cases. And we received 6 articles that offer different dimensions of interpretations of Balzac, some historical and some contemporary. But it was interesting to see how some individuals were thinking about the legal debates only. One of the challenges that we found is that there are a lot of social and political debates that are taking place, but they're not considering how the law shapes the debates. Or the flip side is that you have legal debates that aren't considering what's going on socially or politically, or pay a tangential role to that. So we were trying to expand the debate, and we see some really interesting articles that have different interpretations on the application of Balzac to today's conversation.
Yeah, and I have to say that's so true. As someone who's a New Yorican kind of lawyer looking at it from the legal perspective, I'm constantly having to remind myself to put it together with the what's happening on the island, and so that's why this is such an important contribution. If you could describe some of what you find were the perspectives in this volume that really add to that understanding of the relationship, the struggle for equality, sovereignty, recognition of full dignity of Puerto Ricans, like putting together, right? Were there key contributions and perspectives that you might want to highlight that do that work of putting those pieces together?
So go ahead, Professor Colón Morera.
Well, no, I think that the first article is a very important one. Is written by Ortiz Susoni. Ortiz Susoni is Francisco Ortiz Susoni. He's a lawyer, but he is also a historian. He studied at the Center for Studies for Puerto Rican and Caribbean Studies in San Juan, Puerto Rico. Some people know it as El Centro de Ricardo Alegría. And he made a very interesting PhD dissertation about the case. And here is a short essay where he discusses who was Balzac, what kind of labor disputes were taking place, what was what the labor leader said about the governor, that it was really very festive in its language. So to see Balzac as part of a strategy of the socialist and the pro-statehood movement in that stage of history of Puerto Rico, trying to get the incorporation of Puerto Rico through citizenship, is very, very interesting. And I think people will like very much that article.
Yeah, there's a reference to it that was placed in the chat. Thank you. Okay, so I'm moving right along. Was there anything for both of you that surprised you or that caused you to rethink a perspective on the situation in the pieces that were included among the Centro Journal articles? Was there anything that kind of said, I hadn't thought about it that way, or this is a surprising perspective that you might want to share?
So 2 points I want to highlight. We've been talking about what we've defined or coined as the invisible precedent. It's how the court is moving to cite and apply this discriminatory jurisprudence without citing it, without actually saying, yes, we're going to do it based on these racist opinions. Yeah, so now we talk about precedent. So it's become an invisible way for the justices to apply racist logic today. And we saw that present in a couple articles, not in that language, but certainly the spirit of that argument. A second issue that I thought was interesting is that let
me say something about it. It's very interesting because the court is trying to hide the racial implications of the doctrine. So when you emphasize locality by itself, is if locality suddenly appeared as a...
Oh, you froze.
Luma.
Oh, Luma. I know. I suddenly froze for a moment. So do you want to pick up with that or a separate question, and let's see if he comes back and we'll pick up with that. I was curious about your contribution in that piece that talks about the problem of the liberal narrative of citizenship, why Puerto Ricans are not second-class citizens. Can you tell us a little bit about that piece and why it says that in the title?
So I'm really concerned with three issues here. One is how we analyze the relationship of power between Puerto Rico and the United States. And when liberals and the colonial, post-colonial, trendy academic debates tend to reduce the debate to an individual issue, they ignore what Balzac told us. And Balzac basically said, it's not citizenship is the same. It's the application, it's the status of the territory that determines the application of the law. And we're seeing, I don't want to say similar, but we're seeing something like that taking place with abortion cases, with the Dobson ruling, where the idea of the right to choice is no longer a national right, but it's going to be determined by, I'm sorry, I have a call from Javier Colón Morera here. Sorry. Okay, sorry. Luma, no light.
Luma, no lights. Oh, I'm so sorry. I mean, we're seeing the joining of the theory and the practice and the reality all at once. Unfortunately, yes.
Please so Javier, I'm sorry. Javier sends his regard. So anyway, I'm concerned with individualization of a structural problem. And I am concerned with how academic debates sometimes don't pay attention to the power relationships that define certain types of parameters. In this case, the court tells us it's the same citizenship. The problem is that the law doesn't apply to an unincorporated territory. So any citizen who travels from the United States to Puerto Rico loses rights, and any citizen who travels from Puerto Rico to the United States gains rights, not because of their citizenship or their identity, but because of the status of the territory. Underlying my concern is this idea with democracy. I think the US Constitution is an anti-democratic constitution. Can't vote for a president. Senate is malapportioned. The Congress counts undocumented immigrants to give seats, but undocumented immigrants can participate. And I can keep going on. It's the idea that we have an unequal system of government that is at the core of this idea of empire. And my concern is that liberals gloss over this debate when they say, oh, it's just about first, second-class citizenship. Well, no, these are the same citizens, but your locality, your status changes how the law applies. Now we're going to see some of that debate happening with women who lose the right to control their bodies at a national level, and they're going to be contingent at a state level. It's not the same case, it's not the same parallel, but it's a similar logic that some parts of the United States, the law is sort of suspended.
That's a really interesting, comparison, I have to say, with Dobbs. It's like where you are depends on what fundamental rights you have or don't have, right? Yeah. No, it's a really interesting point. Yeah, go ahead.
And then the second underlying point is this question of citizenship. There's a fetishism with the idea that the Jones Act was the first and last law applied to Puerto Rico. And it's a fundamental misunderstanding because the United States tried to integrate Puerto Rico without incorporating. And that meant that different branches had to deal with the presence of Puerto Ricans in different ways. So what we see in citizenship law is that there are immigration laws that apply parallel to organic laws or laws that are coming from territorial organic bills or legislation. And that's a debate that a lot of people don't want to deal with because it undermines the fixation on the Jones Act. And what I found is that in 1940, Congress, through legislation, applied the 14th Amendment to Puerto Rico and changed the debates because a lot of people were being deported and losing their citizenship every time they traveled and lived outside of the United States. So one of the things that I'm trying to do is clarify the history of citizenship and say, listen, something changed in 1940. Puerto Ricans are now born in the United States, even though Puerto Rico is not in the United States. Okay. And that highlights the contradiction of the so-called doctrine of separate and unequal. When it's convenient, the Constitution applies, and when it doesn't, that doesn't apply. And U.S. territorial law is a contradiction. It's a combination of contradictory policies that enable the discrimination of Puerto Ricans or any U.S. citizen living in Puerto Rico.
Yeah, and I really think it's important that you're focusing on the systemic, on the place, on the location, like how your rights change where you are, and that there's also this on who you are too, right? There's this who it is that's being targeted, and I think about that often in Dobbs and in this. Yeah. I want to segue though to another question. I see you, Professor. Yeah, welcome back. Are you okay? Is everything all right there?
Yeah. I lost electricity. I'm doing it through my phone.
Okay, got it. So I want to bring this last question because we're going to be moving over to Q&A shortly. So there have been numerous efforts to overturn the insular cases, right? Most recently, we just this past term, U.S. v. Madero, which was the case challenging the denial of SSI benefits to Puerto Rico residents as a denial of equal protection. And the court again declined to overrule the insular cases, relied on the territory clause to uphold unequal treatment there. And in that opinion, though, Justice Gorsuch wrote a concurrence strongly stating that the insular cases should be overruled. And so my question is sort of, if they were overruled today, let's say the insular cases, and I'm so glad, Professor Venator-Santiago, you're talking about the broader impacts, because what if they were overruled today? Would that make a difference? Or what difference, if any, would it make for Puerto Rico and Puerto Ricans today, now, or would something more need to happen? And since you're back, Professor Colón Morera. Okay.
Well, I think that probably the Vallejo case is a good example of how, in a way, is to declare the cases to revoke the cases maybe is not the most important issue, because the Baello case is not based on the insular cases. It is based on the notion that territories that have a location and that are treated differently for tax purposes can have a different policy on the part of Congress. It is using the logic of the insular cases,
Right.
but it is not quoting the insular cases. So in some ways, maybe the article that Professor Fernos has in this journal, which basically states that maybe the transition is to have territories that are just plain territories without having the benefits of incorporation, and that there's a new tendency of the court in practice to be more blunt about the fact that U.S. is composed of states and territories, and that those territories can be treated differently. So I think I have to be honest. I don't place too much faith in what the Supreme Court of the United States can do to solve this issue. And I have to say that I agree with one thing with Balzac, that this is a political issue that has to be resolved politically by political means.
I hear you. And there's a lot of conversation and discussion about whether or not the insular cases are drawn in, whether it would make a difference, whether, as was mentioned earlier, no, this is a matter for Congress, because, the court is just kind of shifting, and now it's saying it's not that, it's the territory clause. We have the power in the territory clause. What does that mean? So I want to shift at this moment, though, over to allow for questions and from the audience, if we have them. And I see that we have one question here, and I'm going to read it for our panelists. Could the panelists talk more about what rights Puerto Ricans living on the island do and do not have? Could the panelists talk about more about what rights Puerto Ricans living on the islands do and do not have?
Well, there are two types of rights that are the most important. Well, some of them are political rights that have to do with voting. There's a long line of cases of people identified with the status movement in Puerto Rico trying to get the presidential vote in Puerto Rico. And there's a pro-status lawyer that has been his whole life litigating these issues, Igartua. And the Supreme Court has said that no, the presidential vote is a vote that is connected to the fact that states have electoral colleges, and in order to be able to vote for a president, you have to have an electoral college. You have to be part of that system. And the other issue is the issue of federal transfers to Puerto Rico. Baello Madero is the last case that has reaffirmed the notion that because Puerto Rico receives a different tax treatment than the states, Congress can make different types of assignments or money transfers. And there are some programs like food stamps, like Medicare, Medicaid, where there is a substantial reduction on the funding, and it's a very difficult situation, because in the last years we have faced situations where Puerto Rican government does not know how we will pay for the health services in Puerto Rico, because Congress has not make a decision about how much funding it's going to give to Medicaid or Medicare. So these are really life and death issues.
Absolutely. And so I see Professor Venator-Santiago, and also after you, Kimberly Roa has indicated she wants to ask. Professor?
A quick note, for anybody interested, the U.S. General Accounting Office has a little volume called The Application of the Constitution to the Territories, to the Insular Areas. where it lists line by line the Constitution, what rights apply, what don't apply, and it compares it to all the territories. And that's freely available on the web. And again, the insular cases today are not the same as 120 years ago. And for last time I checked, with the exception of maybe 3 or 4 rights, like the right to trial by jury, the Constitution pretty much has been extended either through jurisprudence or legislation to Puerto Rico. And when it hasn't, Congress has enabled the local government to give those rights through legislation to Puerto Ricans.
Okay, and thank you for that. And I think there's a question in there asking for the title of that GAO report. It's a Government Accounting Office report, and maybe you can probably find it by a search, but if someone has the link and they could put it in the chat, that would be fantastic. And I see Kimberly Roy, I don't know if you wanted to say something live in response to this question. If not, there is one comment that basically says, pardon my ignorance here, I'm here to learn more about the status of Puerto Rico, which is kind of a different question than the focus necessarily on the topic of the CENTRO Journal that we're discussing. I don't know if you want to comment on that, or I can hold that question in abeyance and then move to the next question, and then maybe we can respond after that.
Well, I can make a very short comment. In terms of the U.S. position, it's more and more clear in terms of Puerto Rico being a non-incorporated territory, which means that belongs to the United States, but it's not part of the United States. The Constitution doesn't apply completely, and it is a relation that allows Congress now to make internal decisions about budget, as it did with Promesa recently. So the level of autonomous agency that was promoted and defined and somehow exalted between 1950 and 1952 is in complete crisis right now, because of the fact that U.S. through the Promesa law has taken control of internal finances of Puerto Rico.
Okay, thank you. And that's, I think, yes, right? It's been basically confirmed that it is this unincorporated territory. Some say it's colonial status, others say in another language. Another question for Professor Venator-Santiago, asking to explain a little bit more the difference between second-class citizen and locality. Asking, wouldn't the second-class citizen designation still apply given that rights and opportunities as U.S. citizens living in Puerto Rico are inferior to those individuals living on the mainland?
So again, the problem is that we have the same citizenship. The question is, does the application of the Constitution depend on an inferior citizenship, or does it depend on the status of the territory? So any citizen, whether they're born in New York or elsewhere, that goes to Puerto Rico loses rights. It's not just limited to Puerto Ricans. And any Puerto Rican that travels to the United States gains rights by being in a location. What I'm trying to do is move the debate away from an individual understanding to a structural understanding, so that we can understand how politics defines the status of persons living in Puerto Rico. And that's what Balzac tells us. I'm using Balzac to explain that argument.
To explain that argument, is saying you lose your jury trial rights if you go to Puerto Rico, right? As an example.
You lose all kinds of rights. Not that many, but you lose some rights.
But some, right.
But it's dependent on the status of the territory, not on your citizenship.
Right. And then we have a question, how exactly would the insular cases be revoked? New laws? How exactly do we move beyond them? I could answer those questions, but I'll let you answer them instead. I think, how could the insular cases be revoked?
So in theory, I mean, the court could revoke them.
The court has to rule them, right?
Yeah. In theory, Congress could potentially pass some sort of amendment about territories, but I'm not sure that, I mean, it's complicated. Now, it's interesting because Congress is trying to pass a resolution to censure the insular cases, but American Samoa is saying, no, we love the insular cases because it allows us more rights that normal territories don't have. And it gives us the flexibility to do all kinds of things that territorial law would not allow us to do, including having a non-citizenship nationality, a Samoan nationality.
Okay, thank you. And I'm giving you the warning of that it is, can you believe it? It is time for us to start wrapping up with our questions. And before we conclude, I just like to see if our panelists have any brief closing thoughts that you'd like to share. The remaining questions will be sent to the panelists. Let me do that. And then before we close within a couple of minutes. Any final thoughts? Just put together anything I didn't ask? Yeah.
Yeah, it's important to acknowledge how stable is U.S. policy towards its territories. We're basically under the terms of the Foraker law by virtue of promesa, and we're still under the same type of logic of locality that Balzac enabled 100 years ago. So when we study the past, we're studying the present, and we are looking for ways to escape this colonial entrapment in the future.
Thank you. Professor Venator-Santiago, any closing thoughts?
I want to encourage everybody we have a lot of this information out there, to make a connection between law and structures and politics and everyday society. I want you not to separate these and to engage in a conversation about how power works and what are the limits of power. And Balzac gives us an insight on how the U.S. empire governs or rules Puerto Rico legally.
Yeah, and I have to agree. I said it's one thing, there's the legal implications, but there's so much that needs in terms of education and organizing and action that Congress can take, that the executive can take. And so, getting an understanding of this issue and the status. And so I really, really very much applaud all of you in Centro for this issue of the Centro Journal, for all of the work. I want to say thank you to our wonderful professors, scholars, advocates, Professor Javier Colón Morera and Charles Venator-Santiago, for this enlightening discussion, to Centro, its leadership and staff for putting together this program, and for all of your crucially important work. And to the audience for attending and participating. So great. I wish we could get to more of the questions that are aligned. Unfortunately, we are running out of time. And with that, I will turn it over, I think, to the organizers to help with the conclusion. And I'm going to thank you all very, very much for this important conversation. And I hope everyone who will get a copy of the volume. I don't know if there's information in how to get the Centro Journal volume, but I really encourage you to read it. Thank you all very, very much.
Thank you everyone for coming. I have put a link in the chat for where you can purchase your copy of the latest journal, and we hope to see you at the next Centro event.